Oh, Shelley Keller's on this call.
Who's that?
One of our new attorneys in New York City.
Oh, really? Yeah.
She came with Bernie.
Okay, good.
Yeah, Bernie Kennedy. Yeah.
So she can correct anything I get wrong, maybe.
You haven't met her yet?
No, I don't think so.
She will
What's
correct
her name?
anything you get wrong.
Oh, good.
Shelley Cal.
Shelley Kelly?
Cal, K-E-H-L.
Oh, okay.
Cal. She's a tough one.
Okay, I think we're good.
Okay.
So I can save this. Where's this saving to? Just to the email right now?
I think so.
Oh, shit, it's going to a save screen.
That's all right. You have 5 minutes.
I never fill those out because it's too much work. All right, what do I do?
All right, so then we want to put in, you know how to go to presentation mode, right?
Well, wait, yeah, but where should I save this?
Go ahead, save it there. That works.
I don't know where it's going.
I don't know. It's going to your documents.
Oh, it is?
Okay.
Okay.
Yeah.
So, yeah, presentation mode. Okay.
There we go.
All right, I got time to learn about this case.
4.5 minutes.
Do you know who's doing the next 2 webinars in this higher ed series? Is it John and Pete? Or?
Nobody knows.
Oh, nobody knows?
No.
Why
John's
not?
like, well, I don't know yet.
Oh, okay.
It's in like, because we're, actually, this one has HRCI credit. Did you know that? We got it approved.
What does that mean?
The human resource credit.
Oh, good.
Human resource credit people can
So
get.
that'll promote attendance, right?
Yeah.
Doesn't give me CLE, though, does it?
No. We're working on doing the CLE. It's for CLE, though, you have to be able to track when people get on, how long they're on for.
Hey, I have an unrelated question. I have a client who, a new client, who wants to know what other, it's Sarah Lawrence College, they want to know what other liberal arts schools we negotiate union contracts for.
Okay.
So I know a few off the top of my head, but I'm sure there's a bunch that I probably don't know about. And she needs the SAP because I was the subject of a Michael Moore sit-in, you know who he is, at Sarah Lawrence the other day, saying we were a union-busting law firm, they should fire me. So they're trying, so the in-house counsel's trying to keep me, but there's a lot of political heat, you know, so.
Okay. I can.
How does the question part at the end work? I have to read the questions in the sidebar or what?
I usually bring them up in Word in here, and then I just turn it towards you,
Oh,
and
okay.
you can pick which ones you want.
Sounds good.
Yeah. Somebody submitted like 8 questions before yesterday's webinar. Before it
really?
even started. Before it even started. And then Suba was like, well, I don't see any questions. Thanks, everybody, for attending. But he was in New York City. It was 3 o'clock, and he had to be at Penn Station by 3:40.
This was Suba? He was,
yesterday. So I was like, you know what, I'm not even going to push the question issue.
Yeah. Oh, my
I'm
God.
like, the poor guy's got to get to Penn Station.
Oh, my God.
He was in New York City. John Hall was at his house in Connecticut, and I was here.
Wow. I was in Italy until 2 days ago.
You were.
I wish I was still there.
My sister's been there twice.
Has she? Oh, yeah,
Loves
it's my
it.
second time. It's unbelievable.
Yeah. She goes on all the hiking stuff.
Oh, that's cool.
And they liked her
Think they're
so much the first time she went that she's actually like the tour guide.
Oh, my God.
Wow. Yeah.
That's amazing.
Yeah.
There's so, I mean, we covered a lot on my first trip 10 years ago, but in this trip we covered other places, and everywhere I've been, it's just been spectacular.
Yeah. Alan Griffin's a big traveler.
There's more than, I mean, it's surprising when you start talking to people. A lot of people travel. It's interesting.
Yeah, and they travel abroad, too.
Yeah.
Not like me. I go, you know, Philadelphia. No, not English life. Mm-mm. She's a philosophy professor at Illinois. I know. Wow. All right. Thank you. based on my screen.
I don't know if I have to watch. Yeah, click on it.
Yeah, click on that.
Can we minimize this or get rid of this?
Yeah, click on that
Which
white arrow. Yep. There we go.
Thanks.
All right. And is your contact at Sarah Lawrence getting on this call?
I don't know. I didn't look at the list.
What's her name?
Julie Oster. A-U-S-T-E-R.
Yeah. Anytime they have us just click that, go to one.
You're gonna tell me when we're starting, right?
Yep, we're going to start right now. And she's going to say the broadcast is now starting.
Okay.
Listeners or attendees are in listen-only mode, and then you can start.
The broadcast is now starting. All attendees are in listen-only mode.
Okay, good afternoon, everyone. My name is Ray Pascucci. I'd like to welcome you to the first in a series of 3 60-minute webinars presented by Bond's Higher Education Practice Group. We'll be discussing recent actions by the National Labor Relations Board applicable to private sector colleges and universities that could dramatically affect your operations and your campus community. Today's webinar will focus on the NLRB's new election rules for union organizing. In a nutshell, the new procedures are designed to rapidly accelerate the process, making it much easier for labor unions to organize. We will also cover a recent decision called Purple Communications that gives employees greater access to institutional email systems for organizing purposes. These changes apply to all industries, but we will focus on them in the context of higher education. Next week, on Wednesday, February 4th at noon, the second in our series will focus on a recent decision by the NLRB that is unique to higher education. That decision, called Pacific Lutheran, reinterprets longstanding principles regarding the managerial status of faculty members and as established by the U.S. Supreme Court and its 35-year-old yeshiva decision. The board's new approach in Pacific Lutheran could clear the way for unionization of your regular faculty members. Our third webinar is specifically for religiously affiliated institutions and focuses on another aspect of the board's Pacific Lutheran decision relating to the application of the religion clauses of the Constitution to these institutions. This final webinar is scheduled for Wednesday, February 25th at noon. So with that overview, let's begin with today's topic, the NLRB's new election rules. First, a union versus a non-union workplace. Employment is, of course, a legal relationship. In a non-union environment, the only parties to the relationship are the employer and each individual employee. In New York and in most other states, California being the most notable exception, it is an at-will relationship, meaning continuation is mutually voluntary. Either party can separate whenever it chooses. In a unionized workplace, the union is inserted as a third party, and the employer is obligated to deal exclusively with the union. What that means is dealing with individual employees is now prohibited by law in a union workplace. So with respect to terms and conditions of employment. So unlike an at-will relationship or a relationship that focuses on individualized treatment, you're dealing with the union as a third-party representative, and employees are treated as members of a collective rather than as individuals. Taking a position on labor unions can be sensitive, especially in an academic environment. Unionization has both ideological and political overtones. We're very sensitive about this in the work we do. We know that our clients are often quite sensitive about this, especially in higher education. No one questions that unions have played a vital role in our society. Historically, they were extremely important before many of the statutes that exist today protecting employees in the workplace. But, you know, higher education is a business. We need to manage our employees effectively. We need to be as efficient as we can be in our operations. Instead of saying that the college or the university is anti-union, we would say that you are pro-employee, meaning you value the direct relationship you have with your employees between each manager and administration at large and each member of your staff. You seek to promote collegiality, a culture based on mutual respect and cooperation rather than conflict, which typically characterizes labor management relations. And you believe everyone is better off, including your employees, not just the college or the students, but your employees as well, and that most problems are best resolved by working together rather than working through an adversarial collective bargaining process. The National Labor Relations Act is the governing statute. It covers all private sector workplaces. It establishes the right to unionize. It gives employees the right to choose whether to work in a union environment or a non-union environment. It is administered by an agency called the National Labor Relations Board. The law is neutral. The NLRB is supposed to be neutral. It simply is supposed to enforce the right to choose. When I say supposed to, I'll elaborate on that shortly. It's important to point out here that there are many, obviously, public sector colleges and universities who are not governed by the National Labor Relations Act. They would be governed by state laws, and most of those laws follow most of the principles under the National Labor Relations Act, with a couple of key exceptions. The biggest exception being that unions in most public sector situations do not have the right to strike. Employees do not have the right to strike, which really changes the whole nature of the relationship. And also, there are many layers of mediation and conciliation in public sector that don't necessarily exist in private sector. And of course, there are political factors that come into play. So it's kind of a different, entirely different arena, even though there's a lot of commonality across the different statutes with the NLRA. Okay, potential bargaining units in higher education. Traditionally, higher education is not a new area for unions. They've existed for decades, primarily in the past in the custodial facilities or grounds areas, any combination of those different types of workers, among skilled maintenance workers, among transportation workers, dining and bookstore workers, and much less common, but has existed for a long time, the presence of unions among clerical staff. More recently, there's been some heavy trends toward organizing other groups that are not in those traditional categories in the higher education field. This includes research and teaching assistants, adjunct faculty, and then I have listed regular faculty with a question mark, which I'll talk about shortly, again, referring to the yeshiva decision and the recent change by the current NLRB. Those who cannot organize under the law include any supervisor. A supervisor is any person who has authority to hire, fire, transfer, suspend, etc. There's a series of 12 statutory factors that supervisors utilize, and if they exercise any one of these decisions, then they are considered to be supervisory and therefore part of management. It cannot be part of a bargaining unit. The laws, there's a lot of nuance in this. They can also effectively recommend as opposed to making the decisions by themselves. They are also required to use the exercise of independent judgment. So there's a lot of litigation around gray areas in terms of who's a supervisor and who's not. Managerial employees are also exempted. Managerial employees are those who formulate and effectuate policies for the employer. Traditionally, under yeshiva, most regular faculty members in higher ed are considered to be managerial because they play a role in the governance of the institution, including voting rights under the bylaws, voting on tenure, promotion, etc. There's a lot of committees, of course, that exist that relate to governance that regular faculty are typically a part of. And then there are confidential employees, which is a smaller category of excluded individuals. Those are the persons who have access to the employer's confidential labor relations information. That exception is narrower than some people assume. It doesn't cover everyone who has access to sensitive information. It only covers those people who have access specifically to labor relations information. So it would include typically most or all of the HR staff. It may not include executive secretaries for high-level administrators. One of the reasons why we decided to do this webinar, there have been a lot of changes, of course, in board law recently that we're going to talk about, but we also are aware, and I assume a lot of you are also aware, that there is a very heavy uptick in organizing activity on campuses these days, mostly around adjunct faculty members. The Service Employees International Union, SEIU, has launched a national campaign. They call it Adjunct Action, to organize adjunct faculty members across the country. SEIU has successfully organized adjuncts at several institutions. It's been widely reported in the Chronicle of Higher Ed and in other outlets. SEIU, in case you don't know this, is the largest union in the United States. They overtook the Teamsters about 10 years ago. They're the fastest growing union, and they also are the most effective at organizing new members. They win the highest percentage of elections. They're very aggressive. They're very talented, frankly, at organizing. And they also have a long-standing presence in higher education because they have historically represented traditional groups in the transportation area and among physical plant workers. So the SEIU, they're not the only union that represents adjuncts. In fact, some of our clients have adjunct bargaining units that are represented by other labor unions, but SEIU is undertaking to become the dominant player in this area, just as they've done in healthcare. They are now by far the dominant player in healthcare. The adjunct action campaign themes are pretty generic to all of their campaigns. They focus on the lack of job security. Obviously, adjunct faculty members aren't tenured, but furthermore, they don't hold multi-year appointments or even multi-semester appointments in most cases. They're hired on a semester-by-semester basis. Their pay is considered low compared to, obviously, regular faculty. I've been an adjunct myself for many years. A lot of adjuncts like myself have other jobs, have other careers, and we do it because we're interested in teaching and we want to share our knowledge, and not because the pay is a big issue. But for some people it may be, and certainly the union wants people to focus on that. They focus on the lack of benefits. Again, adjuncts, by definition, most of them are part-time employees. Again, most of them don't rely on the adjunct work as the source of their livelihood, but the union wants to portray them as an exploited group that lacks in benefits, lacks in pay, etc. Lack of institutional support for research and scholarship. They are, people who teach, of course, are engaged in an academic endeavor. If they compare themselves to regular faculty members, they would, who are engaged in many cases heavily in research and scholarship, the adjuncts don't have the support that the regular faculty does for that. Clearly, the adjuncts are excluded from governance. Ironically, if they were included more in governance under Yeshiva, they would not be eligible to be organized, but the union doesn't worry about that irony. They point to the fact that they're excluded from decision-making. And they like to cite statistics, AAUP statistics and statistics from other sources about how on today's college campuses, the vast majority of faculty are actually adjuncts as opposed to regular faculty, with the idea being that they're the ones doing all the teaching, or at least the perception is hopefully created for the union organizer that they are doing the majority of the teaching, and yet they don't receive the benefits, nearly the benefits that the other faculty members receive. With respect to regular full-time faculty, for at least the last 35 years, ever since the Supreme Court's decision in Yeshiva back in 1980, on most campuses, regular faculty have been ineligible for unionization by virtue of their role in governance, their role in the formulation of curriculum and other academic matters, and as a result of those activities by regular faculty, they have been deemed to be managerial employees. The NLRB, of course, does not have the power to overrule a Supreme Court decision, but they have revisited the Yeshiva decision and have reinterpreted it. And they have focused on different factors and, frankly, emphasized what regular faculty members don't do as being key to managerial status, and focus on what they do as being less significant. So it's clear from the analysis, the board's new analysis on this, that the goal is to open up organizing among regular faculty members. I'm not going to talk in more detail about this decision because this is the topic for the next webinar, and it'll go into great detail on that subject. One thing that everyone who works with the NLRB, I think, recognizes, including many of the agency personnel themselves, is that there is some built-in institutional bias. It's supposed to be a neutral agency, but clearly the NLRB would not exist without the labor movement, without unions. The agency tends to attract people with a pro-labor ideology. The agency personnel themselves, the very board agents who conduct elections and investigate them for labor practice charges, belong to their own union. So there's a heavy bias in favor of labor just that's built into the system in terms of how this agency functions. Furthermore, I think it's fair to say, and probably most people would agree, that of all the agencies in government at both federal, state, and local levels, at all levels, the most politicized agency of the government is the National Labor Relations Board. The board is headed up by a 5-member panel that's appointed by the President and confirmed by the Senate. The pendulum has swung back and forth between more pro-business administrations and more pro-labor administrations over the years. There's been a long-standing deal with the Senate that instead of having drastic shifts where you have 5 sort of pro-labor appointees and then it swings to 5 pro-business appointees, the long-standing deal with the Senate is that the administration, 3 of the appointees will be from its party and 2 of its appointees will be from the minority party or from the party that doesn't have the White House, without regard to who has the minority or the majority in the Senate. So the current composition, and by the way, in the first term of the Obama administration, there was a lot of controversy over the lack of a confirmation of appointees to the board, and for a while it appeared as though this long-standing deal would no longer hold up. But we've gotten to a position now where there's 5 members of the board. They're currently fully constituted. There are 3 Democratic appointees, 2 Republican appointees. Like the Supreme Court, you often see split decisions. You often see, as in the Supreme Court, 5-4 decisions. Here in the NLRB, you're seeing a lot of 3-2 decisions. I mentioned the pendulum swinging. The Bush board was considered to be quite pro-management or pro-business. The Obama board is clearly considered to be quite pro-labor. Briefly, the history. The National Labor Relations Act was enacted in 1934. That statute was written at a time when there were no minimum wage laws, no workplace safety laws, no anti-discrimination laws. There were very few protections for workers, and unions clearly played an important role in the early days in terms of securing worker rights. Fast forward to 1954, we still lacked a lot of statutes protecting workers. Unions had become very strong, representing more than 1/3 of the entire private sector workforce in the United States, and completely dominating certain major industries such as steel, auto, construction, trucking, etc. Of course, today is a new day, 2015. Union membership, whereas it historically peaked at 34%, is all the way down to less than 7% of the private sector workforce. Union gains these days have been limited almost exclusively to public sector and healthcare, although they've certainly made attempts within certain very targeted groups such as adjunct faculty and research assistants in higher ed and in a few other industries in some very targeted sectors. They have been able to organize some new members. But for the most part, they have been unsuccessful. The trend has not reversed. It's been a consistent downward trend. There's a lot of reasons for that, which I won't go into here too much. I think, in my mind at least, the primary reason is that the government has become the union for pretty much everyone by virtue of all the statutes that exist now that regulate the employment relationship in terms of anti-harassment, anti-discrimination, safety, wages and hours, et cetera, et cetera, et cetera. So the need for unions is not nearly what it was in the past. And there are other reasons as well. Okay, the union organizing process, how does it work? Typically, it starts with 1 or more disgruntled employees who contact the union. Union organizers are salespeople, traveling salespeople. Their job is to sign up new dues-paying members. They're very skilled, but like most salespeople, they don't rely heavily on cold calls because the prospects for closing the deal are low. So they wait for employees to contact them with issues or problems, and then they quickly try to find out whether or not there's enough dissatisfaction for them to build a campaign around. Having said that, the Adjunct Action campaign by SEIU is a targeted campaign. So whereas in the vast majority of cases it starts with employees reaching out to a union, when there's an effort like this underway, it may well be that the union reaches out to the employees to inquire about whether or not they feel satisfied in their roles as adjuncts, et cetera. Once the contact has been made either way, the union organizer quickly recruits and trains a core group of supporters. These are the internal employee organizers for the union. They identify the target group or the bargaining unit, which could be adjunct faculty, could be one of the traditional units I mentioned, such as your transportation workers or so on. The next step in the process is to gather employee signatures on union authorization cards. This is a necessary step for the National Labor Relations Board. The NLRB conducts elections in the workplace, but they won't conduct elections unless there's a sufficient showing of interest. The way to demonstrate that interest is to gather signatures. The union needs a minimum of 30% in order to file an NLRB petition. A petition is a request for an election, 30% in the appropriate bargaining unit. But unions know that, again, thinking in terms of closing the sale, they're not going to be successful in winning an election unless the majority end up voting for the union. And once they have established a showing of interest for purposes of the petition, the cards are not binding, the signatures are irrelevant, and they have to convince a majority to actually vote in the election for the union. Because of that, most unions don't file, even if they have the 30% or 40%. Most unions won't file unless they have more than 50% signed up, or in many cases, the SEIU, for example, typically wants 60 to 65% before they'll make an attempt at an election. Once they're ready, they file a petition with the National Labor Relations Board. The NLRB then schedules an election. From the union's perspective, the faster the election takes place, the better, and I'll speak quite a bit about that shortly. Actually, right now. Okay, why quick elections favor unions? The union controls the timing of the petition. So in many cases, organizing campaigns are occurring over several weeks, if not months. In a few cases, they can be years. But mostly, it's a couple of months or 6 to 8 weeks or a little bit longer. Can be shorter. But there's quite a bit of time during which the union is basically making a one-sided sales pitch, and it is gathering signatures. And when they decide, though, whether they achieve their target of 60% or 65%, whether they achieved that last month or 2 weeks ago or yesterday, they're not obligated to file the petition unless and until they're ready. So the union controls the timing of the filing. Employers, management often doesn't know that this is happening until a petition gets filed. If we have our antenna up and we're paying attention to our employees and we're aware of the early warning signs, sometimes we know earlier, or the easiest way is if an employee comes and tells us who's been solicited that there's a union campaign underway. But if that doesn't happen, and if we're not paying close attention, we can be caught by surprise. So once the union files its petition, then the employer is notified by the NLRB. That, as far as dictating the timing goes, the union almost always files when they believe they're at their peak strength. Furthermore, they can look at the calendar, and sometimes will file with the idea that the election, the likely time frame for the election, will be, at a time that's most inconvenient for the employer, such as during graduation or finals, or during the busy beginning of a semester, or what have you. In other industries, there are other time frames that the union can target to try to make it difficult. In retail, the holidays, et cetera, et cetera. Also, the reason why a quick election favors unions, and this is the bigger reason really, is that up until then, for the most part, even when management is aware, we're usually holding back on our communication program to see whether or not the union actually is going to end up filing a petition, because many campaigns end up fading and going away without a petition getting filed because the union never gets sufficient strength. So we're waiting to see. We're not doing a lot of communicating typically. That means the union's giving a one-sided sales pitch. They usually have the momentum, they file at their peak strength, and then they look at the calendar, as I mentioned. So for all of those reasons, when the union files its petition, if it could have an election that day or the next day or the following week, they would probably win 90% of those elections. Also, besides timing, there's a huge element to the psychology of the messaging. Unions are selling what everybody wants. They're selling the idea or the hope for higher pay, the hope for better benefits, better job security. Also, they're selling the fear against arbitrary discharge, that you could be laid off, that you could be replaced, that you don't get respect from your employer because you're not involved in any of the decisions that are made. So it's a play on emotions, and it's a play on emotions both from a hope and fear standpoint. Unions are good at generating a lot of excitement. There's a lot of adrenaline involved. People get excited at the idea that we're going to increase our pay, et cetera. Unions rely heavily on bandwagon psychology, camaraderie, the idea that camaraderie that we all need to stick together. And all of this is designed to get people energized and excited about the prospects of change, the prospects of improving their lives. Contrast that with what management has to focus on to try to convince them that it's not the best choice, which is basically practical reality. As a practical reality, wages and benefits are driven by the marketplace. They're not driven by demands at a bargaining table. As a practical reality, the resources of the employer are finite. As a practical reality, the job has to get done. We have to schedule folks in an efficient way. We have to deliver the services to a high standard, et cetera, et cetera. So the unions, this idea that the people can get excited and energized over the hopes and fears that a union likes to foster, means that if you have a quick election, you're much more likely to prevail, because that adrenaline wears off over time, and sort of the more realistic analysis takes time to sink in. And therefore, a management campaign that's based on factual information about the cost of unionization, about the downsides of bargaining, about the risks of bargaining, all of that is sobering, and it takes time for folks to process it, and therefore time is always on management's side. So the speed of the election makes a huge difference. More about why slower elections favor the employer. Again, we're often taken by surprise. We're inevitably starting from behind. The first thing that needs to happen, hopefully the first day you become aware of the activity, or the next day, you need to have a professional labor attorney or other professional educate your managers and supervisors about the do's and don'ts, what the rules are for the organizing process. We do not want to be committing unfair labor practices. We need to quickly gather intelligence about what the union's campaign has consisted of, who they're targeting, what the issues are, what their themes are, what their messaging is, so that we can counter that effectively. We need to quickly analyze any bargaining unit issues that may exist, and we need to participate in the National Labor Relations Board's procedures for establishing an election. Those include a potential hearing in the event that there's disagreements over the scope of the bargaining unit. Is the group that the union is targeting an appropriate unit or not? For example, with respect to adjuncts, does it include only those who teach in the classroom? Does it include those who teach online? Does it include those who may teach at other locations or only at the main campus? Are there quasi-supervisory issues? There's a lot of potential issues, and even though the unit may seem straightforward, the bargaining unit, there are usually issues that are present. And the question is, can we work those out through an agreement, or do we have to litigate those issues and obtain a ruling by the NLRB? To counter a skillfully presented one-sided sales pitch is not easy. Those of you who have been through a campaign know this. We usually have about 6 weeks to work with at the outside. Sometimes you can get longer. I'll talk about that a little bit. Sometimes it's a little quicker, but generally speaking, you have about 40 days, 42 days to run your campaign. That's barely enough time in most instances to convince a majority that this is not a good choice for them. Also, of course, you need to continue to maintain productivity. You need to manage the operation. There are a lot of logistical issues that always create difficulties in campaigns for employers in terms of getting the work done, getting people scheduled, meeting your obligations, et cetera. So for a lot of reasons, management needs time to be successful. One of the biggest tactical decisions that an employer has to make when they receive a petition is whether or not to stipulate to the terms of the election. There's two ways to have an NLRB election. One is to have a stipulation, which is an agreement that is worked out between the union representatives, the employer representatives, and approved by the regional director of the National Labor Relations Board. The other way is to go to a hearing where both sides present their arguments about their differing positions on the scope of the bargaining unit, and then the regional director renders a decision about what the unit should be, and at that point the regional director sets the election. So the petition identifies the unit the union wishes to form. That's part of what they're required to put in their petition. We seek to represent all part-time faculty, or we seek to represent all workers in the transportation department or whatever it is. And then the employer has to decide whether they will agree to that, whether there are issues about either multi-location, other worker categories, quasi-supervisory issues, et cetera, and if we have those and we can't resolve them, then we have a representation hearing. Frankly, I've been doing campaigns for almost 30 years now, and as well as many of my colleagues, and we find that often the outcome depends upon decisions that were made in the early going about whether or not to stipulate and about what the bargaining unit composition will be. Just as in political elections, gerrymandering, people criticize it a lot, but it is a reality of the political process. And who the voting group is or the composition of the voting group can make a big difference in what the outcome is. And so everybody knows that. Pros and cons to stipulating versus going to a hearing. When you stipulate, the voting group is known, so there's no ambiguity about who the audience is for your campaign. The timing of the election is set, so typically once we know when the election is, we'll back up from that date and develop a communications plan around that's targeted to get us to the position we need to be in by the time that election happens. We also, as I mentioned, with the stipulation, there's still some opportunity for gerrymandering there because, at least under the present procedures, the union is very anxious to avoid a hearing if at all possible. It's very anxious to achieve a stipulated election. And the reason is because the hearing slows down the process, which I'll talk about in a minute here. But if you go to a hearing, if an employer goes to a hearing, that can push the election out by 2 to 3 weeks or longer. And the union doesn't want that. They want a quick election. So that gives you leverage. When you talk about bargaining unit composition issues, if you offer to forego a hearing in return for the union agreeing to include some other categories of workers or some other locations, then that may end up becoming part of a negotiated resolution, which gives you the opportunity to influence who's in that voting group. The downsides to stipulating are, for the most part, although despite what I just said, that's usually a relatively minor adjustment that you can achieve by way of stipulation to the petitioned for group. For the most part, the union is going to get the group it wants. If you're seeking wholesale changes, large-scale changes to what the union wants, you're probably going to they're probably not going to agree to that, and therefore a hearing will be necessary. So, sometimes a lot of this is governed by existing board law and existing principles. So sometimes you have a good argument to expand the unit drastically. Sometimes you don't. But when you stipulate, the unit's getting, by and large, the group that it sought. Also, you're setting the stage for a quicker election, as I just mentioned. The election will happen within 42 days by board procedure if there's a stipulation. If there's a hearing, then it stretches out and can be as much as 60 or 70 days out. The pros to a hearing, it's the reverse of what I just talked about. You can expand the voting group or alter the composition by way of a hearing if you're successful with your arguments. Again, we win a lot of elections this way if we have a good argument for expanding the union. The most common way to do that is through a multi-facility approach. If you have nearby campuses or nearby operations, then you can argue that the employees of all sites should be included, or of those adjacent sites rather than employees at a particular site. The hearing process usually delays the election because there are procedural steps that you have to go through, which I'll detail in a moment, that stretch out the process. The cons to a hearing is you don't know who the voting group is going to be until late in the game, because once you get that decision, then the election takes place within about 3 to 4 weeks. So you have less advance notice for sure of who the voting group is going to be. And frankly, the hearing process itself, it's litigation, it's expensive, it's time-consuming, or I shouldn't say time-consuming. It's more about draining resources, but and draining and distracting your attention from the campaign and focusing your attention instead on the litigation. So there are some downsides as far as that goes. Now into the nitty-gritty a little bit here. The board's existing procedures, and these procedures have been in effect for decades. Day one is the day the petition is filed. This is when you have a stipulated election. The clock is shown on the left here. Day one is the day the petition is filed. Day 42 is the day by which the NLRB requires the election to be held if it's a stipulated election. So if the union and the employer agree to an election date that's more than 42 days out, in most cases the board will not approve that and will not allow that to happen. There are exceptions to that, depending on circumstances, holidays or shutdowns, or in an academic calendar, the in-between semesters. So there's a little bit of flexibility, but not much. Example, petitions filed January 1, election must be held on or before February 12. That's the 42-day stipulated election clock. It's been in effect for, I'm not sure exactly how long, but I would say about 25 years. When I first started practicing law, it was 45 days. Before that, it was as much as 55 days, but it's been 42 now for a long time. Under a hearing, if there's no stipulation, then you have to have a hearing. Day 1 is the date the election is filed, so in our example, that's January 1. The NLRB automatically schedules the hearing for the 10th day from the date of filing. The employer has the opportunity to adjourn that up to the 14th day because we don't control the timing of the filing. So the board gives us a little bit of flexibility because we might have scheduling conflicts or whatever. I always routinely ask for, when I get a petition, whether we're going to, I don't know on day 1 whether we're going to need a hearing or not. The board automatically schedules it in case you need it. I automatically ask for the 14th day because I want as much time as I can get to figure things out and also to push out the election in the event we go to a hearing. So in our example, it's filed January 1. The hearing happens on January 14. Most hearings are one-day hearings, but depending on the complexity, it could be a multi-day hearing. Once that hearing, assuming a one-day, day 21 would be the day your briefs are due because you have 7 days to file briefs, post-hearing briefs. In our example, that's January 21. Then you wait for the regional director to issue a decision. These decisions are not one-sentence decisions. They are like court cases. They are, very analytical. They cite precedent. They are subject to appeal. They become part of the NLRB's case law, and therefore, the regional director typically needs time to prepare and write and issue their decision. It's not like court in that it can take several months or a year or longer, but it doesn't usually happen the day you file your briefs. It could. We always mention to our clients that that's a possibility, but it's usually a couple of weeks, sometimes 3 weeks. On the fast side, it might be 1 week. So there's a waiting period, and we don't know what that will be because we don't know exactly how busy the region is, how busy the regional director is, et cetera. Once that decision is issued, the election must be held under existing procedure within the 25th and 30th day. So in our example, assuming a one-day hearing, no extension for filing briefs, you can get those in rare cases, not often, and a decision that issues within 2 weeks, you're going to be talking about a March 1st or the first week of March or the second week of March as compared to February 12th. So the hearing gives the employer anywhere from 20 to 30 days typically for their campaign, and that time can be very crucial. Okay, so from organized labor's perspective, there's been a long-standing problem. Unionization peaked way back in the 1950s. There's been a 50-year downward trend, 60-year now, to the point that they only represent 7% or less than 7% of the private sector workforce. That's really happened mostly because they are not organizing enough new members. The size of the workforce, of course, over 60 years has expanded dramatically. The unions have held on to the bargaining units that they had historically. Some of those companies have gone out of business or downsized or shipped or moved their production overseas or whatever, but they're still, for the most part, once the union organizes a workplace, it's there for the long term. So it's not that the bargaining units that they had historically have gone away so much as it is that they've not kept up with the growing size of the workforce because they've not been able to organize new members. They're losing too many NLRB elections. So the solution to that problem, which is something that President Obama campaigned on when he ran for office before his first term, was that he was a supporter of an initiative called the Employee Free Choice Act, which was a proposed legislative approach to reforming the NLRB's election process to make it much easier for unions to organize. The Employee Free Choice Act would have eliminated elections in many cases. It would have resulted in card check, meaning that if a majority signed union authorization cards, that could be enough to install a union. It had a number of other changes in terms of how bargaining would be conducted for a first contract, including deadlines by which a first contract had to be reached, mandatory arbitration, etc. So the Employee Free Choice Act was something that was a big priority for the Obama administration in their first 2 years in office. It was put on a back burner primarily because of health care reform. By the time you got to the second year or the end of the second year of President Obama's first term, the House of Representatives changed control to the Republicans. The Employee Free Choice Act was dead on arrival, and therefore the legislative solution never became a reality. As we've seen in a lot of other areas, the administration, when it has not been able to achieve goals legislatively, it has relied on administrative or executive action. And so it's up to the NLRB to make changes through its own decision-making process and its own rule-making process that will help reverse this long-standing trend. Now, the NLRB's new rules on election procedures. Quick history here. The board first issued the proposed, what's been called either the quickie election or the ambush election rules 3.5 years ago in June 2011. There was a public comment period. The board issued its final version of the rules, minus some of the more radical elements, in December of 2011. The new rules were initially scheduled to become effective in April 2012. We held seminars, webinars, did blogs back then about all this because just as we had done previously with the Employee Free Choice Act, there was a lot of concern about how this would change the playing field and how it might lead to rapid unionization in all industries, including higher ed, but not just higher ed. But there was a federal court injunction issued which blocked the new rules back in 2012. There was a legal defect to how that rule was approved by the board because at that point in time, Congress and the White House were still fighting over appointments to the board. So the board lacked a quorum. There were only 2 members, so there were 3 vacancies that were unfilled. And the court decided that you can't issue a new rule when you don't have a quorum. So actually there were 3. There were 3 people sitting on the board when this happened, but the Republican appointee abstained from the vote. It was obviously a conscious decision, so that by abstaining, that created the lack of a quorum. Or technically, I don't think he abstained. I think he stayed away. He wasn't present in abstaining. He was not present at all, which meant that the quorum was not there. This basis for blocking the rules, of course, was a technical basis. It does not exist anymore. The board has achieved a quorum and more. It's fully impaneled and has been now for a while. So the new rules, probably they would not be subject to this type of challenge. Subsequent political deals in Washington produced the full board. And then on December 12th, which is just last month, the board voted to adopt, not only re-promulgate the proposed rule, but they actually reverted to the original, more radical version of the rules that were first proposed 3.5 years ago. Back in 2011, after the public comment period, the board backed off on some of their changes to make the rule more palatable to business, or somewhat more palatable. And when they reissued it here in December of 2014, they went back to their original approach, which was a series of changes that are designed to really rapidly accelerate elections. Again, the board, when it voted in December, it was a 3-2 vote. It was the 3 Democrat appointees versus the 2 Republican appointees. However, it's not subject to a procedural technical challenge the way it was 2 years ago or 3 years ago. There will be court challenges. Whether they succeed or not, it's unclear. A lot of folks, including myself, believe that it's unlikely that these rules can be stopped at this point. The new rules will become effective in April of this year, meaning just in a couple of months. And if you have a union organizing campaign, after that, it's going to be a whole different ballgame in terms of how employers can conduct campaigns. So, what the new rules do. First, they establish electronic filing of petitions to save processing time. That's not a big change, but it does shorten the procedural clock by 1 or 2 days. The hearings must be held within 8 days instead of 14. That takes 6 days off the clock. There is a new mandatory pre-hearing position statement that has to be filed by the parties, which gives you less time to figure out what your position is, to do legal research, to gather evidence, and to make arguments. And instead, not only will you have less time to figure that out, but you will no longer have the opportunity to file a post-hearing brief, so that the mandatory pre-hearing position statement will become your only argument, and therefore 7 days are taken off the clock for the briefs. It eliminates hearings for any voter eligibility issues involving less than 20% of the unit. A lot of these cases, frankly, like most elections, most political elections, it's that middle 5 or 10% who decide most elections. You've usually got 40 or 45% of the electorate who feels one way and 40 or 45% who feels the other way, and then it's the people in the middle who decide the outcomes. Same is true in these union elections often. So when you might go to a hearing over a group that's only 10 or 15% of the unit or even 5% of the unit, but that could make the difference in the outcome. A lot of these elections can be very close, or even a tie vote. We've had many tie votes over the years. Now the board is saying you can't go to hearing if it's anything less than 20%, which is a high threshold. So basically, you're not going to be able to have a hearing in most of these cases, because to have an argument that to be able to expand the unit by 20% would be a rare situation. Also, the new rules eliminate pre-election appeals of the regional director's decision. The NLRB, of course, is a federal agency. It's national. It has offices all over the country. The 5-member panel that sits in Washington is the head of the agency, but there are regional offices and regional directors around the country. Here in New York, we have regional directors in Buffalo and Manhattan and Brooklyn. And they are the ones who decide if there's a hearing in a representation case. They decide what the scope of the unit is. They resolve all the issues that are litigated. And the party that is dissatisfied with that decision has the right to appeal to the NLRB in Washington. And you have 14 days to make your appeal under present procedure. Under the new rules, there are no appeals anymore to the board in Washington, no pre-election appeals, and therefore that's 14 days off the clock. And then the last big change is that the employer is required to produce what's known as the Excelsior list, or the list of eligible voters, within 2 days instead of 7 days, which is the present time frame. So there's 5 days off the clock. So when you add all that up, it dramatically shortens the time frame from filing a petition to date of election. And especially under the existing procedures, before these new rules take effect, if you would have a hearing, that could push the election out as far as 60 or 70 days. Under the new rules, you're probably not even going to be able to have a hearing, and you're not going to get your 42 days. You're probably going to get something more like anywhere from 10 to 20 days. It will vary from case to case depending on the specifics, and there are different estimates of what the ultimate impact will be. But, my experience tells me that we're going to have, under these new rules, if they become effective, we're going to have very, very fast elections. We're going to have elections inside 20 days in almost all cases, I think. And what's 20 days? That's 2 weeks, 2.5 weeks. That's very little time to convince your employees on that voting for the union is a bad idea, especially when you go back to what I talked about earlier, which is the way a union organizes. It relies on hopes and fears and emotions and excitement and adrenaline, and that's going to be very hard to overcome in a short time frame. Okay, the impact effectively removes the employer's right to a pre-election hearing in most cases. I just talked about that, depriving you of a key tactical tool. Where a hearing is still possible, it creates higher downside risks for the employer. In other words, you're going to have no appeal. You're going to have less time after you've had the hearing from decision to election, because you don't have that pre-election right to appeal. So you're going to, if you take the risk of going to a hearing under these new rules, whatever that decision ends up being from the date of decision to date of election is going to be, could be 5 days, 10 days, very short. It effectively prevents you from leveraging the threat of a hearing to obtain a favorable stipulated election agreement. So it takes away your bargaining power to obtain a favorable stipulation, which, frankly, is something that I have been, in my practice, we go to hearing probably in about 20% of our cases, but we get favorable stipulations. In other words, we leverage the threat of a hearing to, tweak the composition of the bargaining unit probably in 60% of the cases that I work on. So, that's a huge tactical tool that will no longer be available. And then the bottom line is the current 42-day clock is cut in half or worse. There is another development that is important to be aware of. It goes back to a decision by the NLRB in 2011 called Specialty Healthcare. It was not a higher education decision, but it has been interpreted since then to apply without regard to the type of workplace. What that decision did was it reversed 20 years of board precedent, and the board precedent was that you had to, for it to be an appropriate bargaining unit, if you could show that the employees had a community of interest with one another, they had similar skills, similar terms of employment, similar terms and conditions of employment, then they would have to be included in a common bargaining unit. So as opposed to the union being allowed to basically cherry pick or selectively organize micro units or one particular job classification. We had a case, for example, right after specialty healthcare that was in a manufacturing setting, and for decades the prevailing appropriate bargaining unit would have been all production and maintenance employees or all production employees with or without maintenance. In that case, the board sought to organize, or the union sought to organize only the assemblers, which was just one category of production worker in the factory. And we litigated, and the regional director found that under specialty healthcare, if they wanted to organize just the assemblers, they could organize just the assemblers. This has had a huge negative impact on an employer's ability to challenge the proposed unit. But as I talked about before, you could try to expand the unit through the hearing or alter the composition. That's a lot harder now, so it doesn't really make a difference in an adjunct faculty campaign, which is already pretty targeted, but it could make a difference in other areas on your campuses if the union is trying to organize, let's say, the drivers in the transportation department, but not the dispatchers, or the dispatchers, but not the drivers, or the bookstore workers, but not the dining service workers, et cetera, et cetera. So the union has much more latitude now to target and to selectively choose who to organize. When you combine that with the new fast-track elections, clearly this will have a huge, huge impact. There's another decision I want to mention. It's called Purple Communications, a very recent decision by the board. If you work in the field that I work in, you know that the SEIU is the largest and fastest growing union. We face them a lot in these cases. They're also the ones who are running the adjunct campaign. Their color is purple. I think this is a coincidence, but it was when I first heard about this decision, I heard it was called Purple Communications. It was just amazing to me that sort of the irony that that's the SEIU color. But what this decision does, that was the name of the company in the case. Of course, that's how these cases are named. But what that decision does is it overrules a well-known decision called Register Guard, which held that an employer's email systems, your file server, is your property, and that employees can't use that for other than business purposes, or presumptively can't use that for other than business purposes. And many of you probably have policies that say that. But under Purple Communications now, the NLRB has overturned Registered Guard, reversed course, and said that because so many people communicate these days electronically, and because employers often exercise little oversight with respect to how employees use their email system, that the presumption now is that employees who otherwise have access to the system, this is not for people who don't otherwise have access, but employees who otherwise have access to your email system can use it for organizing purposes during their non-work time, during their breaks, their meal periods, before and after their scheduled hours, for organizing purposes. This is a big issue. A lot of these campaigns, I've been through some very recent higher ed campaigns where there was a lot of controversy over the use of the file server, and under this new board decision, which isn't a higher ed decision, it's a decision for all industries, all businesses. But I can tell you, it gives the union a lot more access. In the old days, before we had emails, the unions had a pretty significant disadvantage because the employer controlled the workplace is on private property, union organizers were non-employees, they had no right to access your private property. You probably all have a no solicitation policy that says that, and therefore they had to rely solely on their internal employee organizers. But with emails, with texting, with cell phones, unions effectively have full access to your employees. It was always more difficult for higher education because Your campuses, even though they're private property, are pretty much open to the public. There's visitors all the time who are entering and exiting the property. But it is private property, so if you knew that there was an organizer on campus, or if the organizer wanted to hold a rally or something, a demonstration, you would have the right to prevent them from doing that and exclude them from the property, and you still do, but it's not as important nearly anymore as it was back then for the organizers to obtain that kind of access because of the whole electronic age where they can access people this way. And under Purple Communications, they can create their own email list or their own from yours, use your system to effectively get out all their messaging. So what do? The ambush survival plan, this quickie election rule has often been called the ambush election rule. There are certain steps you could take. If you want to prepare yourself for the possibility of a union organizing campaign, one way is to conduct on a regular basis, could be annual, could be every 2 years, proactive supervisory training so that your managers and your supervisors know what organizing is, what it looks like, what the early warning signs are, what the rules are, so that you don't get caught short and not being prepared and making mistakes that are going to hurt you, etc. You can look at your workforce, your existing workforce, identify potential bargaining units, consider unit placement issues. Do you have quasi-supervisors who are in a gray area? Can you clarify their roles by changing their job descriptions? You should look at your policies, your existing union-related policies, your no solicitation clause, your policies pertaining to email access, posting, etc. Also, if you have a no loitering policy, you can revisit those to make sure that they're lawful so that you don't run into being caught by surprise and then having an unlawful policy that gives the union a grounds for an automatic second election if they lose the first election. You should closely monitor your employee satisfaction, whether you use surveys or not. At a minimum, you should have HR playing an active role in monitoring employee relations, setting up committees to meet with groups on campus to talk about on a regular basis, maybe quarterly, maybe monthly, to talk about any concerns or issues people may have, to try to be more responsive to those concerns. We call that soliciting grievances, or the board calls that soliciting grievances. But basically, you're asking folks, are there any problems? Are there any issues? Are there any concerns? Sometimes you can resolve those. Sometimes you can't. But at least when you communicate about it, it makes people feel a lot better about having been able to express their concerns and having you listen and respond in whatever way you're able to respond. The other thing that some of our clients are beginning to do is to prepare ready-made campaign communications, especially that first. Typically, when we first find out about organized activity, we quickly do the training, which you can do proactively. We also quickly put out a letter to the employees. This is pre-petition, explaining that union authorization cards are legal documents, that they're not obligated to sign them, that they should consider very carefully whether they do that, and you could have that letter ready to go. If you could develop a 21-day game plan for a campaign, you could conduct a campaign fire drill, meaning you pull in all your key players, you talk about who would have what role, etc. So there's things you can do to get ready in case you're hit by a campaign under this new in this new environment. But even with all that, frankly, it's going to be very difficult. So we'll see if these rules become effective. I think they will. Most people think they will, and then we'll see what impact that has. But it looks like it's going to have a pretty detrimental impact for employers who want to maintain the direct relationship with their employees. Okay, a little bit of time, not much for questions. What do we have? No questions? Okay, we have no questions. So I'm actually going to end early. Thank you all for listening. We have the other webinar coming up on February 4th. The third is on February 24th. I did want to mention, with respect to Purple Communications, I briefly talked about that decision. One of my colleagues did a webinar on that decision back in December. If you go to bsk.com, you can access that webinar if you want more information about that. As always, you can contact myself or any of our other labor attorneys at Bonshenik & King in any of our offices with specific questions or with any follow-up. Again, thank you all. Have a great day.